Imagine getting a phone call on a Tuesday morning telling you that your father has passed away. In the fog of that first week, somewhere between planning a funeral and calling relatives, someone mentions a word you've heard before but never really understood: probate. You assume it's a formality, a signature here, a stamp there, and within a few weeks the house, the savings, the belongings will be sorted out and passed along the way your father intended. Then months go by, then a year, and you're still waiting on a court date, still filling out forms, still wondering why something that should feel simple has turned into one of the most drawn-out, confusing chapters of your grief. If that scenario feels uncomfortably familiar, or if you're trying to plan ahead so it never happens to your own family, you are exactly who this video is for. Today we're going to talk honestly about how long probate actually takes in 2026, why it varies so wildly from family to family and state to state, and what actually causes those long delays that nobody warns you about ahead of time. Before we go further, a quick and important note. I'm not an attorney and nothing in this video is legal advice. I'm an educator who focuses on helping families understand how estate planning and probate generally work, so that when you do sit down with a licensed professional, you're asking the right questions and you're not caught off guard. Probate rules are set at the state level, which means the process, the timeline, and even the vocabulary can look different depending on where your loved one lived. Everything here is general education. For anything specific to your situation, you'll want to talk to a licensed estate planning or probate attorney in your state. So why does this topic matter so much right now? Because more families than ever are stepping into the role of executor or personal representative without any warning or preparation. People are living longer, families are more spread out geographically, and many adult children have never had a conversation with their parents about what happens after they're gone. When that moment arrives, the person left holding the paperwork is often overwhelmed, grieving, and completely unfamiliar with how the court process works. Understanding the general timeline and the common causes of delay can be the difference between a probate process that takes 6 months and one that drags on for 2 or 3 years. By the end of this video, you're going to understand the general range of time probate takes across the country, the handful of factors that most often stretch that timeline out, and a few practical steps that can help your own family avoid becoming a worst-case story. If you find this kind of plain English explanation helpful, consider subscribing, because we cover these estate and retirement planning topics every single week, and this channel exists to help you and your family feel less lost when these moments come. Let's start with the basics. Probate is the court-supervised process of validating a will, paying off a deceased person's debts, and distributing what's left to the rightful heirs or beneficiaries. When someone passes away, their assets don't just automatically transfer to their children or spouse, unless those assets were specifically set up to do that ahead of time, through something like a beneficiary designation, a jointly held account, or a living trust. If an asset was owned solely in the deceased person's name, it typically has to go through probate before it can legally change hands. The process usually starts with someone, often the executor named in the will, filing a petition with the local probate court. If there's no will, the court appoints someone, usually a close family member, to serve in a similar role, called an administrator. From there, the court formally opens the estate, and the executor or administrator is given legal authority to act on behalf of the estate. This is the point where people often think the hard part is over. In reality, it's just beginning. Once the estate is open, the executor has to identify and gather all of the deceased person's assets. That means tracking down bank accounts, retirement accounts, real estate, vehicles, and personal property, and getting a clear picture of what actually belongs to the estate. At the same time, creditors have to be notified, because the deceased person's debts don't just disappear. Most states require a formal notice period, often somewhere between 3 and 6 months, during which creditors can come forward with claims against the estate. This waiting period alone accounts for a significant chunk of the overall probate timeline, and it's a legal requirement, not something the executor can simply skip to speed things along. After the creditor period closes and any valid debts, taxes, and expenses are paid, the executor can move toward distributing the remaining assets to the beneficiaries. Only after all of that is done does the court typically allow the estate to be formally closed. So when people ask how long probate takes, the honest answer is that it depends heavily on how complicated the estate is, whether anyone disputes the will, how backed up the local court system happens to be, and how organized the executor is from the very start. Let me walk you through an illustrative example to make this more concrete. Imagine a family where a mother passes away, leaving behind a modest estate, a house, a checking account, a car, and a will that clearly names her oldest daughter as executor. There's no conflict among the siblings, all the paperwork is in order, and the daughter is organized and responsive. In a situation like this, especially in a state that offers a simplified process for smaller estates, probate might realistically wrap up in 6 to 9 months. That's still not fast, but it's manageable, and it reflects what a relatively smooth probate case can look like when the family is prepared and cooperative. Now imagine a different family. A father passes away, and it turns out he never updated his will after a second marriage, so there's ambiguity about whether his current spouse or his adult children from his first marriage are entitled to certain property. One sibling suspects the will was signed under pressure and decides to contest it in court. Add to that a piece of real estate in another state, a retirement account with an outdated beneficiary form, and a court system that's backed up with a growing caseload. In a situation like this, it's entirely realistic for probate to stretch well beyond 2 years, with legal fees quietly eating into the very inheritance everyone is waiting on. This is exactly why estate planning attorneys so often talk about the importance of updating your documents after major life events, and why disputes among family members are one of the single biggest factors that turn a routine probate case into a multi-year ordeal. Let's talk about the general national picture, understanding that this really does vary by state. For a relatively simple, uncontested estate, many probate cases take somewhere in the range of 6 months to a year to fully close. Some states have adopted simplified or summary probate procedures for smaller estates, which can shorten that timeline considerably, sometimes to just a few months, if the total value of the estate falls under a certain threshold set by that state's law. On the other end of the spectrum, complex estates involving real estate in multiple states, family disputes, unclear wills, or significant business interests can take 2, 3, or even more years to resolve. It's not unusual to hear about high-conflict probate cases that drag on for the better part of a decade. The point isn't to scare you, it's to help you understand that probate isn't a single fixed process with one universal timeline. It's a range, and where your family's situation falls on that range depends on a handful of predictable factors. So what actually causes probate to take longer than families expect? The first and most common factor is simply the completeness of the estate plan itself. When someone dies with a clear, up-to-date will, organized financial records, and named beneficiaries on their retirement and insurance accounts, the executor's job becomes dramatically easier. When someone dies with an outdated will, missing documents, or no will at all, the court often has to spend additional time sorting out who the legal heirs even are, which naturally extends the process. The second major factor is family conflict. Even in loving families, grief has a way of surfacing old tensions. Disagreements over who gets the family home, questions about whether a will reflects the deceased person's true wishes, or simple miscommunication between siblings can turn into formal legal disputes that pause the entire probate process while the court sorts things out. Contested wills are, without question, one of the single biggest reasons a probate case stretches from months into years. The third factor is the complexity of the estate itself. A single bank account and a paid-off house is a very different situation than a small business, multiple rental properties, or assets spread across several states. Each additional layer of complexity typically means additional paperwork, additional valuations, and in some cases, additional court hearings. The fourth factor, and one that people rarely think about, is simply the backlog of the local probate court. Just like any other court system, probate courts can become congested, especially in larger counties or during periods of high caseload. An executor can do everything right and still find themselves waiting months longer than expected, simply because the court's calendar is full. Finally, tax issues can extend the timeline. If an estate is large enough to potentially owe federal estate tax, or if there are complicated income tax matters tied to the deceased person's final year, the executor may need to wait on tax clearances before the estate can be fully closed. This is another area where working with both an accountant and an attorney becomes important, since the interplay between estate administration and tax obligations can be genuinely intricate. Now let's clear up a few common myths, because misinformation about probate spreads quickly, often through well-meaning friends and family who mean well but don't have the full picture. The first myth is that having a will avoids probate entirely. It does not. A will actually has to go through probate in order to be legally validated and enforced. What a will does is give the court clear instructions and typically name an executor, which can make the process smoother, but it does not skip the court process altogether. The tool that's specifically designed to help assets bypass probate is generally a properly funded revocable living trust, along with beneficiary designations and jointly titled accounts, not a will by itself. The second myth is that probate always takes years. As we talked about, plenty of straightforward, uncontested estates move through the system in well under a year, especially in states with simplified procedures for smaller estates. The horror stories you hear are often, though not always, cases involving conflict, complexity, or missing documentation. The third myth is that the executor can move as fast or as slow as they personally want. In reality, executors are bound by mandatory waiting periods for creditor claims, court filing deadlines, and procedural requirements set by state law. An executor can certainly slow things down by being disorganized, but they generally cannot speed past legally required waiting periods, no matter how motivated they are. The fourth myth is that probate is always expensive and always drains the estate. Costs do vary, and yes, attorney's fees, court costs, and executor compensation can add up, particularly in contested or lengthy cases. But a straightforward, well-organized estate can move through probate with relatively modest costs compared to the size of the estate. The families who tend to see the largest chunk of their inheritance eaten away by fees are usually the ones dealing with disputes, litigation, or significant disorganization. So what can you actually do, either as someone anticipating being an executor, or someone thinking ahead about your own estate? Start by having an honest conversation with your family now, while everyone is healthy and clear-headed, about where important documents are kept and who is expected to serve as executor. If you're the one planning your estate, make sure your will is current, especially after major life events like marriage, divorce, the birth of a child, or the death of a beneficiary. Review the beneficiary designations on your retirement accounts and life insurance policies regularly, since those forms often override what's written in your will. Consider speaking with a licensed estate planning attorney about whether a revocable living trust makes sense for your situation, since a properly funded trust can allow many assets to bypass the probate process entirely. Keep a simple, organized list of your assets, account numbers, and important contacts somewhere your family can access it when the time comes. And if you're currently serving as an executor, stay organized from day one. Keep a dedicated file or folder for every piece of correspondence, every receipt, and every court filing, because that organization alone can shave meaningful time off the overall process. At the heart of all of this is something bigger than paperwork and court dates. Probate exists to make sure that when someone passes away, their wishes are honored and their debts are settled fairly. But the process can feel cold and bureaucratic during a time when what your family really needs is space to grieve. The families who tend to move through this most smoothly aren't necessarily the wealthiest or the most legally savvy. They're the ones who had honest conversations ahead of time, kept their documents current, and understood, even in a general sense, what to expect. That's really what this channel is about, helping you walk into these moments with a little more clarity and a little less fear, so you can focus on your family instead of scrambling to understand a system nobody ever really explains to you in plain language. If this video helped you understand probate a little better, do me a favor and subscribe, because we publish new videos every week walking through exactly these kinds of estate planning and retirement topics in plain English. And if you found this helpful, share it with a family member, because chances are someone in your life is either facing this right now or will be one day, and a little preparation can spare them a lot of stress. One last time, because it matters, everything in this video is general education, not legal advice. Probate laws, timelines, and procedures vary significantly from state to state, and the specifics of your family's situation can change what applies to you. Before you make any decisions about a will, a trust, or an ongoing probate case, please talk to a licensed estate planning or probate attorney in your state. Thanks so much for watching, and I'll see you in the next one.